The Fifth Circuit just ruled in a case that challenges the NFA and suppressor restrictions as a violation of the Second Amendment. And the Fifth Circuit just found that suppressors are not arms, and therefore they do not trigger 2A protections. So let's break down what just happened in this critical ruling. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Brownells. You guys know that Brownells is an amazing company. They support the Second Amendment. They support this community here. They love what I do here on the channel, and they just wanted to support us. So if you want to give your business to an amazing company, check out Brownells. And also, if you use my code SCHOLAR10, you can get 10% off of any of your orders. As I mentioned in the intro, in this video, we're going to be discussing a suppressor challenge that was just ruled on by a 3-judge panel in the Fifth Circuit. This case deals with the constitutionality of the NFA as it applies to certain suppressors. The case we're going to be discussing in this video is U.S. versus Peterson, and this is a case that we've covered before, and it involves an individual who had a gun store at his home, which was raided by the ATF. Now, during this raid, the ATF found a single solvent trap that was not registered or serialized, and because of that one item, Mr. Peterson was charged with violating the NFA and was charged criminally. Mr. Peterson and his attorney tried to get that charge thrown out using a motion to dismiss, and they argued that the NFA is unconstitutional under the Second Amendment as it applies to suppressors. The district court denied that motion, finding that the silencers in question are not bearable arms protected by the Second Amendment. That decision was reviewed by the Fifth Circuit, and they just ruled that they agree with the lower court that suppressors are not arms, and therefore they do not trigger 2A protections. So we need to break down what just happened in this critical ruling and what happens now. Now, the facts around this case are interesting. Both the ATF and Mr. Peterson kind of tell a different story. And according to Mr. Peterson, on June 29th, 2022, both federal and state law enforcement officers executed a warrant at his home in Louisiana. The local sheriff executed a search warrant and an arrest warrant based on some delinquent sales taxes that he hadn't paid, and the federal task force included the ATF and along with 50 other law enforcement officers. Specifically, the ATF alleged that there were straw purchases, improper record keeping on 4473s, a failure to complete and forward multiple firearms purchase forms to the ATF, and other issues relating to some products that were sold at his gun store that later arrived and were found at crime scenes. During this raid, federal agents seized his entire inventory, totaling about 300 firearms, and also his personal firearms as well. Now, out of this entire incident, the one thing that jammed him up and was actually reviewed by the Fifth Circuit here was the fact that a single solvent trap was found in his safe, which was in his bedroom in his home. As a result of that, he was charged for being in possession of an illegal silencer in violation of the NFA. Now, in response to that charge, Mr. Peterson filed a motion to dismiss the charge based on the Second Amendment. On August 21st, 2024, the court denied his motion to dismiss the indictment. And based on that, Mr. Peterson then appealed the case up to the Fifth Circuit. He appealed the denial of the motion to dismiss, arguing that it should have been dismissed based on the Second Amendment. Now, the question the Fifth Circuit considered was whether or not the district court erred by finding that silencers are not bearable arms covered by the Second Amendment, or even if so, whether Mr. Peterson's indictment for possessing an unregistered silencer violated the Second Amendment. Now, in the ATF's brief to the Fifth Circuit, they first argued that suppressors are not arms protected by the text of the Second Amendment at all. The ATF argues at best these are simply accessories, but they are not accessories which are necessary for the operation of a firearm, and therefore they are not protected. The ATF also argued that even if these are arms, they are still dangerous and unusual items, and because of that, they can be regulated and restricted because they are dangerous and unusual. The ATF's last argument to the Fifth Circuit for the constitutionality of the NFA's restrictions on these suppressors was that even if these items are protected, the Second Amendment right is not burdened by a registration process to possess these items. The ATF claimed that the NFA process here is a shall issue permit scheme, and therefore it's permissible even under the recent Supreme Court Bruin decision. Bruin, in some dicta by Kavanaugh, mentioned that shall issue CCW permit schemes may be permissible under the Second Amendment, but now the ATF took the position that the NFA registration scheme is shall issue and similar enough to actually pass Bruin's standard. Well, the Fifth Circuit recently heard oral arguments and then they issued their decision on this case. The Fifth Circuit just sided with the ATF, finding that Mr. Peterson's motions were properly rejected because the Second Amendment does not protect the items at issue. In this ruling, the Fifth Circuit stated that Peterson first challenges the district court's denial of his motion to dismiss. Specifically, he argues that the NFA suppressor registration requirement unconstitutionally burdens his Second Amendment rights. But because we conclude that suppressors are not arms within the Second Amendment's purview, we disagree. They went on to state that whether suppressors constitute arms is an issue of first impression in our circuit, and so far as we can tell, every court to have addressed it has decided the question in the negative. Here, the Fifth Circuit looks at whether a suppressor is actually a weapon of offense or an armor of defense, or is it used to cast at or strike another. Here, the Fifth Circuit incorrectly finds, in my opinion, that they are not. So they found that they are not actually arms and that they do not meet those requirements. The Fifth Circuit states in the opinion that Peterson posits that suppressors are an integral part of a firearm and therefore warrant Second Amendment protection. Inasmuch as a bullet must pass through an attached suppressor to arrive at its intended target, suppressors are used for casting at and striking at, and thus fit Heller's definition. But the Fifth Circuit believes that is wrong. A suppressor by itself is not a weapon, they say. Without being attached to a firearm, it would not be of much use for self-defense. And unless a suppressor itself is thrown, it cannot do any casting or striking. While a suppressor might prove useful to one casting at or striking at another, that usefulness does not transform a gas dissipator into a bullet caster. Instead, we agree with the 10th Circuit that a suppressor is a firearm accessory, not a weapon. And while possession of firearms themselves is covered by the plain text of the Second Amendment, possession of a firearm accessory is not. So this is what the Fifth Circuit is saying. They're saying these are simply accessories, they are not arms, and they are not necessary for the operation of a firearm. The Fifth Circuit went on to find that suppressors are not necessary accoutrements of a firearm that are required to make a firearm useful or actually function. And based on that, they upheld the lower court's decision in denying the motion to dismiss based on the Second Amendment. Now, inherently, of course, this is a very concerning decision. The fact that the Fifth Circuit found that suppressors are not necessary and that they're merely accessories, it kind of brings into question what other so-called accessories courts may deem are also not protected by the Second Amendment. Some courts might find that maybe a forward grip on an AR, maybe optics, slings, stocks, or maybe other types of so-called accessories are not protected by the Second Amendment at all, and therefore can be outright regulated, restricted, or even banned. And the question also becomes, what about magazines? You may have some courts that find that magazines are simply accessories and not arms necessary for the operation of a firearm. You don't necessarily need a magazine to fire a single round out of a firearm, so the question becomes, what is necessary for the operation of a firearm? The question also becomes, how far is this whole non-necessary accessory exception actually going to be taken when it comes to the two-way context? So what does this mean? Well, going forward in this case, the question is whether or not Mr. Peterson and his attorney will seek en banc panel review in the Fifth Circuit. Are they going to seek a reversal of what the three-judge panel said? If you remember, I was actively trying to get other two-way organizations to actually support this challenge, or at the very least to file amicus briefs when this was pending to be heard in front of the three-judge panel in the Fifth Circuit. None chose to actively do so, but I do hope now with this horrible decision that came out of the Fifth Circuit and some of the posts of these organizations acknowledging this decision, saying that it's horrible, I would hope that some of them would now get involved maybe at the en banc panel level, at the very least, if it's sought, and maybe also still file amicus briefs if it goes up to the en banc panel. So again, a very important case and very important decision. Unfortunately, I predicted that this is the way it was going to come out after we listened to the oral arguments in front of the Fifth Circuit. There was also some issues with how this was briefed, going up to the Fifth Circuit. The plaintiff's attorney here was not expressly trying to use Bruin in the history and tradition standard. Instead, they were trying to still use the old two-step approach, which was rejected by Bruin. However, the Fifth Circuit on review still looked at this in the context of Bruin, but ultimately it didn't even get past the first kind of analysis of Bruin because the Fifth Circuit found that these are not arms at all, and therefore they didn't even move on to looking at history and tradition. So again, very important. We're going to see how this develops going forward, and if we get any more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.